Okay, everybody ready? Good morning, Friday. I really wish this class was on Monday like it used to be. I'm sure you guys do too, but we'll make do. Today we're going to talk about contract law and contract formation. So the bulk of what legal issues are going to come up, as we talked about last week, there are two areas where it's going to impact your lives. This, hopefully, knock on wood, is significantly larger in percentage as far as an impact on you. But this is contract. We'll talk about contract. In a couple of weeks, we're going to talk about torts. Those are their injuries. And so hopefully, during the course of your practice, you don't ever have to have an incident where someone has been injured on one of your project sites. And even more, hopefully, that if there is an injury on a project site, because they do happen, it's not due to negligence on behalf of the designs that you worked on or your firm worked on or otherwise. But those are the two main areas, as we said last week, about where claims are made, contract and tort. So today we're going to talk about contract law generally, and then the formation of contracts and how they're formed and what they really mean and how they impact you guys and what they mean. And then next week we're going to talk about contract disputes, what happens when there's a breach of contract, and a resolution of that. So today is how we get into the deal, and next week is if the deal goes south, what do you do about that? Okay? So, the theory of the contracts. And this is the basic. It's drilled down to the very simplest. And interestingly enough, yesterday I was driving my 10-year-old son to drop him off at school. And he said, "Daddy, what do you do at your class? Like, what are you going to talk about tomorrow?" I'm like, "I'm going to talk about a contract." And he's like, "Well, what does that mean?" And I said to him, "And it's agreement between two or more people that's enforceable under law." I didn't even say enforceable under law. I just said it's agreement between two or more people. I said, one person says, "I'll give you something," and the other person says, "I'll give you something in exchange for that." Whether it's money, whether it's services, it's an agreement. That's all it is, between two or more parties. What makes it important for you guys, and I didn't need to get into this with my 10-year-old, is that it's enforceable law. That document, that oral agreement, that understanding between the people that makes up the form of this contract, you can enforce in a court of law or through arbitration. And that's when you come to people like me to help say. Now, where the problems and questions come in is, well, what was that agreement? Did I agree to this or did I agree to that? If it's oral, it's a lot more difficult to figure out whether you agreed to one thing or the other. But the purpose of it, and this is about your business and everything else, the purpose of having a contract and to coming to that agreement is to tie down predictability, to see what's tied on the future. We all go into a project as designers, and we are asked by the client, "Design me this hospital, design me this office building, design me this home." And in our minds, because where we go, and you guys got to remember, my first love, and still is my first love, is architecture. So I think this way first, even though I've been a practicing lawyer for over 20-some years, is that we think we're going to deliver to our client the designs, and we don't think about necessarily what steps we have to take to get there. But the client, they have their own idea of what's going to come at the end of the rainbow here. And so the contract, that agreement in writing or otherwise, between you and the client, or you and a number of people, depending on how many are part of that client, the agreement is to establish predictability. What's going to happen? When am I going to get schematic designs? When am I going to get design development? How long is it going to take to prepare the construction documents? When the project starts, what are you going to do as the architect? Those are things that the owner, depending on their level of sophistication, may be thinking. Or the owner may be just thinking is, how do we get from the beginning to the end? You guys are thinking as far as tying down predictability. Okay, I want to do a schematic, and I'm going to come up with ideas. But before I go further, what kind of approval are you going to give to me? What kind of notice to say, yes, I like this, and it's going to be in writing or otherwise? What am I going to get paid for those services? How many hours am I expected to put in? Part of what you want to do in your contract when you're negotiating it is that you are to say, well, this project is going to take X number of man hours or people that are going to have to be on the team. And that's something, even interestingly enough, when you go back and have to do your budget reports to your bosses and you have to figure out how much your workload is, You're going to look to see what your projects are and how much time, and that's going to be baked into what you decided is in the contract. What's the value? So it affects future predictability on both sides. And then the most important thing, I think really the most important thing with respect to where we get into the contract itself is, was there a meeting of the minds of this bargain or trade? Did, when I said to you, I will deliver these design drawings for you by June, did I mean design development? And did the other side think it's going to be finished construction documents because then they can go out and send out the project for bid? Was there a meeting of the minds? Or what exactly was going to be paid for? What is free, what is not? All these things that you need to have and distill down. And so as a result, the contract, and that's why it is my strong implicit recommendation that every deal, every project you guys get into over the course of your practice should be in writing. And at the end of the class, not today, but the end of the semester, the very last, or second to last lecture is just kind of prepping for the final and everything else, but the very second to last lecture, we're going to talk about an actual contract that you guys can use. We're going to go through the AAA documents, but I'll give you guys a contract that you can use in your practice. We'll go through the provisions and how you want to use it. And that's something that, whether you guys are freelancing now or you go out and you ultimately go work for, you can keep that in your as an arrow in your quiver to use going forward. But I think every contract should be in writing so we understand what the meeting of the minds is. Now, I will tell you this, even with written contracts, there are still issues and questions that come up about the meeting of the minds, and litigation ensues from that. In fact, one of the biggest lawsuits I had, we had a 3-week trial in federal court in Michigan many years ago, and the contract was very clear about what the owner needed to do. I was representing the design builder, and we felt that the contract was very clear on what the owner was required to do. And in the course of a deposition, which is a written or oral question and answer session that's under oath, after we've done all this discovery information, fact gathering, and everything else, we finally got one of the senior people from the owner, who was the party suing my client. They were suing them for $8 million. I finally had a senior manager sitting down at the table, and I asked them for 2 days, lots and lots of questions. And many of the questions had interlaced elements to lead to a final provision in the contract that we felt, if he agreed that it said what we believed it said, if we could get him to say the meeting of the minds was X, we could win the case. And in fact, when we finally got to that point in the deposition, and I put that provision in front of him, and I asked him to read it into the record, as he read it, he started slowing down because he realized all the other stuff that he'd said leading up to the path boxed him in, and he could only answer one way. And as a result of that provision, we went to court on motion practice before the trial. It's called a motion for summary judgment. And we wrote and we said, look, this is what he admitted in his deposition. And the court was going to rule on this motion and would have dismissed the entire case. We were about 6 weeks out before trial. And then I got a call from my client. And they found a box of documents under a desk. And in that box of documents were drafts of the agreement leading up to this point where they signed the contract. And that one paragraph had all this handwriting by my client as they were negotiating. And there was terms and conditions of what the ideas about what that provision meant in those drafts. And under law, we had to turn that information over. And so they immediately came back and said to the court, you can't rule on this motion because this is germane to whether there was a meeting of the minds on this provision. And so the court was furious at my client and furious at me because I think he was ready to rule in our favor, and we probably would have never gone to trial. But as a result, he yanked everything, and we went to trial. We went for 3 weeks of trial, like I said, and all of this information came out in front of the court, and there was a large discussion between witnesses about these paragraphs that came up literally 6 weeks before the case went to trial about what they meant to establish what the meeting of the minds was. Now, ultimately, the court found in our favor, which was great, so we ended up winning the case. We always felt at the end of the day it said what it said and it meant what it meant, but that shows you how important the understand that the parties came to the meeting of the minds. We were in this litigation for 3 years, and all the way up until the very end, there still wasn't people that could agree on both sides of what this contract meant. So So no matter what, you still should have it in writing, because that's what we ended up prevailing on, what was in writing. But there can be disputes over what the meeting of the minds is. But the purpose is to try to show what that bargain is. Okay, so I think probably the best way to show you that contracts are very simple is, let me show you a quick video here. I hope the sound is loud enough here, because I only have my laptop.
I pay particular attention to this first part because it's most important. There's the body and the fight part should be known in this contract as the body and the fight part. How do you like that? That's pretty neat, eh? No, it's no good. What's the matter with it? I don't know. Let's hear it again. There's the body and the fight part should be known in this contract as the body and the fight part. That sounds a little better this time. Well, let's go on. Would you like to hear once more? Just the first part. What do you mean, the body of the fight part? No, the first part of the body of the first part. Alright, it says the fight part of the body of the fight part should be known in this contract as the fight part of the body of the fight part should be known in this contract. Look, why should we quarrel about a thing like this? You say it right out. It's too long anyhow. Now what do you have there? Well, I have about a foot and a half. Now, the body of the second part should be known in this contract as the body of the second part. Well, I don't know about that. Now, I don't like the second body either. Well, he should have come to the fight party, leaving me to home around 4 in the morning. I was blind for 3 days. Hey, look, why can't the first part of the second body be the second part of the first body? There you got something. Well, look, rather than go through all that again, what do you say? Fine.
So, our good friend Groucho Marx talked about, and interestingly enough, this clip goes on for about 10 minutes, and he goes through this whole contract, and it shows one of the biggest problems that I think that exists in the law today. Hopefully, it's I like the way I like to draft, is that everything is over legalese and overdrafted, and it's a language all in and of itself. But you can see, granted, this is humor. But even coming out of the box of who is whom, the two parties in the agreement, who's going to be coming to an agreement the way it's written, the normal person can't figure it out. So that just goes to show you that a meeting of the minds, even from the very beginning, granted it was humor here, is difficult. So the second thing, again, we'll give you the contract. And even when we go through the AAA documents, there are going to be provisions in there that I think are not well drafted, that they aren't as clear as what they need to be. I think what I try to do, and what I hope you guys get from this class, and what I try to do just in my practice in general, is to try to take the legalese out of the law, try to take the complexity out of it, and try to distill down into the documents and what we have between the parties and what we have for contracts and agreements. It's just exactly what the agreement is between the parties. And hopefully you guys, when you get out there, and when you're working for firms and doing what you want, if someday you are asked to sit down in a contract negotiation, or even if you enjoy this class or just enjoy the business side of the profession and you volunteer for that, maybe you can draw a little bit on what we learned here, because I wanted to try to say to you that the purpose is to distill things down so that the normal person can understand it. You don't have to have a law degree to hopefully understand what's in the contract. Okay, so in addition to just the contracts, there are different types of contracts. We have written and oral, which we'll get into a little bit, but there are certain ways the contracts are put together. So we have in here, we're going to talk about express, implied, and quasi-contracts. Okay? Now, express contracts are traditionally what you're going to see that are written contracts and oral contracts. It's the expression between two or more individuals. It's very basic. It's very simple. I'm telling you to do this, or I'm asking you to do this, and in return I will give you something, or you're going to say I will do X for you in return for getting Y. It's being expressed, whether written or oral, between the parties as what that agreement is. The better contracts, as I said, are written because we can track them later. It's not to say that an oral contract is a bad contract. In fact, you can sit down and have a very good oral contract and establish and express between the parties what everybody's going to be doing. But what happens is when something goes south later on, and you go back and point to that meeting, Memories aren't as clear. People might have had a different interpretation. So that's the benefit of a written one. But that's an express contract. An implied contract is implied in fact. It's not written or oral. It's by the actions of the people. So when you go, my example here says visiting a vet or a doctor or a dentist or any place that you go, even when you walk into a store, you expect them to give you a service. You go to the doctor. Can you make sure to see if in fact I have a flu? Can you do an examination of me? You take your dog into a veterinarian. You expect them to provide you a service. You never have a conversation, my guess is, with the veterinarian, the doctor, the accountant, whomever you are. While you're being examined, you know I'm charging you for this service. But everybody knows that that person's going to be paid. Now, there may be, like in my profession, one of the things that happens in the beginning is I send an engagement letter and we say what my rates are, and so there is sometimes a discussion about rates. But by and large, there's an implied in fact agreement between the parties, and that's called a quasi-contract, that there is an understanding of what the agreement is. So you're going to find quasi-contracts a lot more in service-type professions. When you go to the store, and this is an interesting point right now that's changing with Apple and Amazon and everything else, but you go to Walgreens, you go to the grocery store, and you pick up a bag of chips. There's a quasi-contract. There's an understanding that if you want to take that out, you're going to go to the front register and you're going to pay for it. You don't walk into the store and have to sign a paper that says, I agree that everything I take, I'm going to pay for on the way out. That's another quasi-contract. The interesting thing, as I said, as I mentioned Apple and Amazon, is both of those now, Apple, if you can actually pay for something on your phone and walk out, you don't have to go and see somebody and check out. And in Amazon, they have these pop-up stores. I don't know how many in the country. I know there's one in the Chicago area where you walk in and they have cameras all over the place. Have you guys heard about these stores? And it's not like the refrigerator in the hotel room when you pick up the little bottle of wine or candy and they charge you because of the weight. The machines, the cameras and everything else is using photo recognition, and they know that your phone, because you're tied into Amazon, they know who you are. And you gather all the stuff up and you walk out. You don't even have to check out on your phone. And then you're walking down the street and you'll get a text or an email from Amazon that says you took X, Y, and Z and they're going to pay for you. That's a quasi-contract that's already been established between the parties, that you are going to abide by the rules and they are going to properly charge you. So, nothing writing, nothing orally, it's a quasi-contract. Applied contract. A quasi-contract is something that's implied in law. So, it's imposed if neither party originally intended there to be a contract or someone was unjustly enriched. So here, my example is the veterinarian assists the pet. Okay, so what does that mean? If you are out on the street and there's a dog that's not doing well, and the veterinarian comes up and provides a service, then there's an argument there that potentially that veterinarian could get paid for that, because in law, they're providing a service. It's a quasi-contract. It's implied in law. So there didn't need to be, it wasn't an agreement between the parties. The individual wasn't going to the veterinarian. Something happened to cause the parties to come together. And it is recognized that that person that offering the services should get paid for that. So the law will enforce that. You can't say, well, I didn't go to that veterinarian. He or she came up and helped me, so I shouldn't have to pay for it. No, the law is going to impose this quasi-contract. They're going to impose that and say, yes, but you understood, even though you didn't go to them in front, you didn't do it on your accord. It was understood that you were going to receive those services, and therefore they're going to imply that contract, or they're going to enforce the quasi-contract. Does that make sense? Okay. Now, with contracts, there's also things called unilateral and bilateral contracts. So, a bilateral contract is what we traditionally think of an agreement between two or more parties. Yes, go ahead.
Thinking of what you just said about the vet on the street, and then the person just drove the truck. So, what if like this person is my job, my job suddenly has some kind of sickness? I make this person, and he doesn't tell me that he's a person, and just or whatever it does to help my job. So I still have to use a lot of help by me when I don't know the event or something.
So that's a great question. So the question is if there's this need for service, and taking the example of that you're out on the street and your animal is sick and someone comes up to help out, if that individual doesn't identify that they are a veterinarian, that they are performing a professional service for which the individual performing the service would expect to be paid, are you liable or obligated to pay that individual? And the answer to that question is, I don't know. And I will tell you this, and this is the other thing that I think lawyers are bad at doing. They are bad at saying, I don't know. Because we all try to impress our clients and think that we know everything. I have no problem with telling a client, I don't know. But I always follow it with, I will find out. And that's what I'm going to try to do and find out for that. My suspicion is how that would be treated as follows. Is there would be two things that you, as the individual receiving the services, could make the argument that you do not need to pay. Number one, even though you receive services, I didn't ask for them to give me services. So there was never a meeting or an actual request from me. They were offering out of the kindness of their heart, kind of the Good Samaritan type law. And number two, you could also say, which is the genesis of your question, I didn't know that they were performing these services in their professional capacity. I just thought this was an animal lover. And so when they came in and helped me split my dog's leg or whatever the issue was, or if it's something that happened to me or what have you, why would I ever expect or anticipate that I would have to pay this person for the service in addition to them doing out of the goodness of their heart? Because I just thought that they were somebody that maybe had some knowledge, but not a professional. So the question specifically for that, I'm not sure, but that's your argument of not paying. On the flip side, the person that's providing it says, hey, this is what I do for a living, and the actions that I did, I should get compensated for my services. And so that's where you would have a dispute. Now, what I'll try to do is I'm trying to think of another example, and if I can come to another one other than the veterinarian that would put a good quasi-contract out as an example. But if not, next week I'll come back and give you some more things to kind of clarify that. So there are arguments on both sides of why they should or shouldn't be paid, but the point of the quasi-contract theory or issue is that neither party knew that there was some agreement going on between them. They didn't think about that. There wasn't an anticipation for like an implied contract where it's all implied. I went to the store, so it's implied if I take something, I will pay for it. Whereas in this situation, they didn't know that there was this law out there, but in fact the law requires them to be in compliance with that. Maybe a better way of potentially like a quasi-contract would be in the construction world is that if there is going to be work performed in accordance to the code, well, neither party may not know that the code exists, but in order to make sure that the building is up to code, the parties have to act in accordance with that. One party has to build in accordance with the code, and so there could be an argument. There's a quasi-contract that's implied under the law and enforceable under the law that the building that's being constructed needs to be in compliance with the code, and therefore the individual providing those services should be paid. So, does that help your answer? Okay. All right, bilateral and unilateral. So bilateral is the exchange of mutual promises to be completed, performed, or promise of future performance. And that's between different parties, bilateral. So we have exchange of mutual promises. If I give you this, you will give me that. There has to be an exchange of promises, of one party giving to the other. So it's not necessarily, bilateral is not the concept of you have two or more parties. That's just to have any contract. It's that both parties, as a part of the deal, are putting something into the deal. So it talks about completed performance and a promise of future performance. So I promise I will prepare design drawings for you. You promise to pay me. Once you have completed that performance of preparing the design drawings, you have completed the performance which triggers the obligation of the other party, the bilateral obligation, that they need to pay you. They will pay you, they promise to pay you in the future. So that's how those things work, is it's mutual obligations on both sides for a bilateral contract. Unilateral contracts, only one person has to make a promise. The example, it says no promise of performance by the contestant. The individual in a contest doesn't have to do anything to be part of it. Probably every year McDonald's has their Monopoly thing where you go in and you get the little tags and you stick them on a board, and my kids, or we go to the Jewel, they love to get the little Monopoly tags, and they're like, hey, can we figure out, are we going to win the trip to Hawaii or the $1 million or whatever? And I try to explain to them, because they're 8 and 10, that no, we're probably not going to win that because it's 1 in X millions of chances. But any contest like that you are in is a contract, but it's a unilateral contract. You need not participate. You need not to promise anything to be a recipient and a beneficiary of the agreement or the contract. So, if you think about it, yes, when you go into McDonald's, normally what happens is to get those little peel-offs, you actually have to buy food, and it's stuck to the wrappers or part of the fry container or what have you. But there's that fast-talking guy on every commercial that, void where prohibited, blah, 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 and it says, that it'll say, need not participate. And if you read the little instructions on the Monopoly board that you get from McDonald's or Jewel or any of these contests, when Dr. Pepper promotes tickets to get to the NCAA college football championship or everything else, there's a set of rules. And on the back of that set of rules, in very teeny tiny print, it'll say, you need not buy anything. You don't have to buy our product and unscrew the cap and look on it and see, I'm a winner. All you have to do is write a letter to this address. So you don't have to be a participant in purchasing. You don't have to have an obligation. You can just ask to be part of the contest. Every single one of those has that. And that has to do with the laws in the states about contests. Because if not, if they don't have that little paragraph that says you need not participate to be part of the contract, it's now considered gambling. It's when you're in Vegas and you give money to put down on cards. And actually what's going on in Las Vegas is actually a contract. There is a deal going on, a mutual deal between you and the casino. If I pay for the value of a bet in this card and I win, you are going to pay me back. That's a mutual bilateral contract you have when you go gambling. But most states don't allow to have gambling. But they want to have these contests. McDonald's wants to have contests in every state of the country, or Dr. Pepper, whomever it is. And so they must include that paragraph that changes it from a bilateral agreement, both parties need to participate, to a unilateral. So that's the difference between the two. Understand? Clear? Okay. When you guys are going to be out there, everything you're going to be doing as an architect is going to be a bilateral contract. You're never going to enter into a unilateral. Well, I take that back. The times you might be in a unilateral contract, and some of you guys may have already done it, is a design competition. Whether it's now while you're in school or whether you get out there, you don't have to give them you have to give them your design, but you do that all by your choice. And you send the design in to them, and if you win, you may win accolades or you may win money. You don't have to necessarily they may have some rules and parameters, but it's not like you have to buy something from them to be part of that. So anytime you guys are in a design competition, that's a unilateral contract. Work-wise, performances of services when you get out there and you're working for a living, those are all going to be bilateral contracts. Okay, now we're going to talk about whether a contract is valid, invalid, void, or unenforceable. Okay, so a valid contract's pretty simple. This agreement between parties, there's a mutual exchange of obligations, we spell out what we're all going to do, when we're going to do it, who are the parties that have the authority to sign it, all those other things. That's a valid contract. And by and large, every contract, hopefully, that you guys are going to enter into will be a valid contract. But that is an element that you guys, when it comes to me, one of the first things I'm going to do is review the contract and make sure it's valid. If it's not valid, if someone's coming and trying to make a claim against you, if it's a void contract, if it's voidable, or if it's unenforceable, one of those may be defenses against a claim. Say, well, we signed it, but the contract's void. So let's talk about a void contract. A void contract is not legally valid, unenforceable at any point. So it doesn't matter if the contract had a meeting of the minds. It doesn't matter if the contract spelled everything out. The contract from the day it was executed is void. It never existed. That's a void contract. So an example here would be if it's illegal. Okay? If I came to you and said to you, I want you to design for me this hotel, and it's going to have these kind of cool spaces and rooms. It's a small little boutique, intimate hotel. And it turns out that the purposes for that hotel was actually that the person that was hiring you is going to turn into a brothel. The contract between you guys to perform the services of designing that space is actually a valid contract. Now, if the client asks you to do things specifically that furthered the criminal activities that were going to go on, and you know that maybe portions of what you were doing were void because it's an illegal activity. If someone came to you and says, I'm going to pay you money to run drugs over the border, you can't come back to them and say, I had a contract with you. You're going to pay me $100,000 to run these drugs over the border, because the actions that you were doing, it was illegal. So that agreement, providing services and being paid for it in that instance, is void because the action's illegal. Now, it could also be against public policy, so that maybe not necessarily something that's a statute or criminal thing on the books, but it's not something that people would normally approve of. So, are you being asked to design a building that may be in violation of a code? It may not be a criminal activity, but something that you know that's going to violate a code is against public policy. And so you could make an argument that, well, we never really had an agreement, that contract was void. Probably the most important thing that you're going to see is minors, where contracts are void. If you enter into a contract with a minor, anybody under the age of legal consent, which is typically 18 in most states, there cannot be a contract because that individual has not the legal ability to enter into a contract. So any agreement with a minor is void. Now, the place you're going to hear about this from time to time is with child stars. So people that are in Hollywood or in the theater or the entertainment industry, and occasionally you're going to hear someone that wants to, they actually sue for emancipation. Because the parents, up until a certain age point, up until their legal age of consent, are the only people that can enter into the contract, because the child can't. One of the things that my 10-year-old son, he doesn't watch as much anymore, but he used to watch it like almost every day. There's this little boy, I think he's from out east in the Carolinas. He does this unboxing of toys. In 2018, he made $22 million for people going to his YouTube channel to watch him open up the new Nerf gun or the new Lego or the new slime. And that's all he does. And he gets hundreds of thousands of dollars of toys that the toy companies send to him. And he brought his sister into it, so they now do that. They can't enter into any of those contracts. None of that $22 million is his. It goes to the parents. Now, the parents may set up a trust, and there may be some legal issues with that, but there can never be a contract between Mattel or whoever sends the toy that says, we'll send you this toy if you do the unboxing, because we know you have 15 million followers, like my kid. He says, Daddy, I want this, I want this, I want this. And they send those toys, and they give the toys for free, and then they give him advertising money. They can't enter into the contract with that little 10-year-old boy. He's really good, by the way. I don't think you guys have ever seen him. But and he's one of the top three or four highest earners. I just was reading this at the end of the year on YouTube for unboxing type stuff. Like $22 million for this little 10-year-old. They donate all the toys to charity and everything else. But that contract or any agreement with him would have been void because it's unenforceable and not valid from the very beginning. A voidable contract is it seems to be valid and legal, except can the process be performed? Is it something that would be ultimately, can you make it voidable? Okay? So the question here is withheld information or misrepresentation. So I enter into agreement with you, and I tell you I want you, for an example here, I want you to design a space for me, but I don't tell you all of the points and elements of that. I withhold information. Now, of course, that would entail, and so when you try to deliver it, you can't deliver because you don't know all the facts and circumstances. Now, of course, one argument you would make is that there was not a meeting of the minds because I didn't know the true purpose behind the reason for the building or whatever the service that you're asking me to perform. I didn't know all the facts. But that may not be a full defense, because if it's design this building for me and do this and do this and do this, it actually may describe everything that you as the design professional need to have a meeting of the minds and an understanding of what your services are. But let's say later down the road, when you go to collect your money for the work, for the performance of the services, for the building you design, and the owner comes back to you or the person that retained you and said, but it didn't do this, this, and this. And you're like, well, you didn't tell me that's what you needed. So it's, well, I didn't think you needed to understand. The building's not performing and functioning the way I want it to. You could say, well, there was never you withheld that information purposefully. You knew it in the beginning. I didn't. I designed it in accordance with these parameters. Therefore, our contract, even though it seems valid, I'm going to make it void. It's a voidable agreement. As opposed to from the outset. A void contract is not example from day one, doesn't exist, cannot exist. A voidable contract, at some point in time in the future, you presume it's a valid contract, but circumstances and elements come up, and again, the most important, the bigger issue, the more common things are like a misrepresentation or without information, comes up to show that it is a contract you are going to say voidable. Here's an example of one contract that I had, and you use an example of a legal tool called rescission, and that's the process of making what's a valid contract voided. Is I had a client, and they ended up purchasing a house in a subdivision at the bottom of a hill. In fact, I actually had this with my parents, but it was much smaller, so I'll use the example at the bottom of the hill. What the people didn't understand is that the previous homeowners, there was flooding, because it's at the bottom of the hill. And the developer had done improper civil work, and so there was a number of houses around it that flooded at the end of this culvert, because the water came down and they didn't have the proper overflows and the water would go in. And the people that were selling the house had what they had done is they had some flooding, but they made the basement look clean and they painted it out. You couldn't tell. There wasn't the smell of mold and mildew and everything else. So the real estate contract was, I will sell you my house for $650,000. I will turn this over. You've had an inspection. You came and looked at it. We all think everything's cool. Everything's great. But the homeowners didn't tell of the previous incident of the flooding. So you go into the contract, you purchase it, you move in, and then 6 months later, you find out you're going to experience flooding, and then you talk to your neighbors, and they say, oh yeah, we had that problem too. They had it the worst. Their houses, we all flooded. We've had to fix our houses, and it was because the developer screwed up with the civil engineering work. This is the exact scenario that happened here. Clients came to me, and I said, well, there's 2 options you can go here. You can go into the route of fixing your house. You can spend the money to put in drainage tiles. You can do what your neighbors have done, and we can fix it, and we can sue them for restitution. Your cost that you incurred to make the house whole, to put it to a position of where it should have been, what you thought you were buying, and what's that cost? $100,000, $200,000. What's it going to cost to fix this? I don't know. You guys go out and find out. And their response to me was, we don't want to live in this house. We're worried even if we get the flooding under control. We don't know how bad it was. If they just painted out the drywall, what's behind the walls? Is there going to be mold? Are these going to be health risks to our children? Is it more than just getting the drainage tiles and stopping the flooding? How far up in the house has it gone? Because if you guys all think about the traditional balloon frame house, it can go up from house. You can have mold growing on the 3rd floor, even though the water came in only on the basement. And they were really adamant about this. They had a child that had allergies, and they said, we want to get out of this contract. And so I sued under the law, it's called, I sued for rescission. We are rescinding the contract and saying this contract, while it was seemingly legal, they withheld this information, and now we are rescinding it in its void, saying we need to go back to the beginning. We are going to move out. You are going to give us all $650,000, plus we asked for some additional costs for what they had to live in and suffer, but not the repair, and you get the title of the house back and you deal with it. So that is a voidable agreement. Legal from the beginning, but it turns out the withheld information made it illegal or voidable. And the last one is an unenforceable contract. This is a valid contract that cannot be enforced in a court of law. And it has to do, and it's kind of like a void contract, but not necessarily. So the void is it's from the very beginning. An unenforceable contract just says once we get into court, we're going to see if the contract on its own can be enforced under the laws. So example here, capacity, duress, fraud, unconscionability, safety, unfair, mistake, public policy, etc. And then also this thing called the statute of limitations, which is a legal term we'll talk about throughout this semester, but I'll explain it here. So capacity. So obviously a void contract, if you enter into a contract with a minor, that's something that it doesn't exist from the very beginning. But if you enter into a contract with an adult, someone that is of legal age consent, seemingly that's a valid contract. There was a meeting of the minds. But if later on down the road it's determined that when the party that entered into the agreement did not have the proper mental capacities, you on the other side would not have known. Of course you're going to know if there's a 10-year-old child unboxing your new Nerf gun that person can't enter a contract. But if I'm entering into a contract for a 42-year-old individual, I may not know that he or she has lack of mental capacity at the time. They could have been on medication. There could have been things that happened that caused them to not have the proper capacity to enter into the agreement. So it's under the law, it would be unenforceable. Duress and fraud. If somebody's lying to you and tells you stuff specifically, it's a little different than up here when we're talking about withheld information. If someone purposely defrauds you, that's an unenforceable contract. So if we were in the scenario where my homeowner, if they had asked, have you ever experienced flooding, and they said no, that goes from withheld information to fraud. Okay? And in that instance, they're going to say, you defrauded me, and so we would sue on fraud, commercial fraud, in addition to with rescission. So that is a contract not enforceable because there's a legal issue. Fraud is a legal issue. Unconscionability, safety, and unfair, those are public policies. Was it safe to enter into this agreement? Mistake, and again, a public policy. So if all of these things come up that are factored into it, the court's going to say, under the law, we can't enforce this contract. So it becomes valid. It was valid, but there are applications in the law that says it's not valid. The last one here, the statute of limitations and delay. So for that situation, and again, this will be probably the most common thing you're going to hear, or not common thing, but you'll hear this every now and again in cases, especially in architecture, because problems that happen in the building are rarely found out on the day you move in. You design the school, everything's fine. About a year after the building's been designed and built, there's some leaks in the gym. That's no big deal, that's what happens. We've got a freeze-thaw cycle. And then 3 or 4 years later, maybe 6 years later, you find out that the building, you get a call from the school district and they say, we have had constant leaking in this, and we actually finally hired someone because it was just a slow drip in the beginning, but now it's a deluge every time we have a storm. And we go in and we investigated and we hired this expert, and they said, you guys screwed up in your design. You have breached the contract. So we're suing you. Because we have this contract with you that says, I will perform in accordance with the standard of care. I will give you a leak-free building. Pretty much. Because nothing's perfect. But that's what you're asking. That's what you're giving to them under the contract. And so they sue you. In every state, there's what's called a statute of limitations. In this limited period of time, they can sue you in this window. And if it's later than that window, they have lost their right. And that's common sense. It's to say, because, think about it. Let's say you get a call 15 years later. You designed this building for me, and it leaks, so I'm suing you for it. You're like, come on. How long do I have to be on the hook? So statute of limitations takes a valid contract. I will design for you a leak-free building. And it says, that's valid. We all had an agreement. You did the work, they paid you. But they need to sue you if it leaks within a certain period of time. And we'll get into later in different questions and stuff how long and why it's that limited window. But if it's outside of that window, then the courts are going to say, I can't enforce this valid contract because the claim is too late. Does that make sense? Okay. Yes, back there. Yes. Yeah, the claim would go away. So what happened is I've had many cases where I got out of statute of limitations. In fact, I just won on a statute of limitations. It was a multi-million-dollar case that we had out in Rockford in federal court, and the litigation had been going on for years, and we weren't the first lawyers in. But 2 or 3 lawyers later, we finally got hired, and we started going through the investigation. And there was a 1-year statute of limitations. I actually represented a surety, which is the company that provides the bond. And there were problems with the project, and the party that was suing my client was a subcontractor that didn't get paid. And the reason why the subcontractor didn't get paid is because the general contractor, whom the subcontractor was working for, basically went bankrupt. So there was no money to pay the subcontractor, and they said they were owed about $2 million. This was a government job, so as a government job, you have to have a bond. And a bond is kind of like a security that there's this surety out there, mostly insurance companies, that says if you, subcontractor, don't get paid for whatever reason and you did your work, we are going to step in and make sure you get paid. So the subcontractor couldn't sue the contractor because the contractor bankrupt. Subcontractor can't sue the owner because the subcontractor doesn't have a contract with the owner. They don't have any mutual way to sue that. So the subcontractor made a claim on the bond. And we were being told that we needed to pay the $2 million that were owed. The case actually went on for 9 years before we got it. So there was actually, the interest that was being generated was almost as much as the claim. So it was going to almost double that. And as through the course of discovery and everything else, we found out that the individual who owned the subcontractor, he knew that he wasn't going to get paid, and he knew all the information about when he should have been paid. And he had 1 year from that date to make a bond claim. And he missed it by 6 days. And so we had a hearing on it. After all this depositions and literally hundreds of thousands of dollars, probably millions by both sides, in litigation costs and everything else, we finally got this stuff, we nailed it down, and we went in and we went on a motion and we put the briefs in front of the judge, and the judge read it, and he said, well, this makes a lot of sense, but there's not enough, we need to have a hearing. So we had more litigation and all this other stuff, and we actually then went in and we put witnesses on the stand in front of the judge. And it was all about when did the individual that owned the company figure out that he or she, or he in this case, had a bond claim, and when did they file that claim? And they found in favor for us, case was dismissed. So my client didn't have to pay the $2 million or whatever ultimately. We never had a full trial on the merits. It was all gone. So just poof, by a statute of limitations. It was a valid contract that the sub had with the general contractor. The bond was a valid agreement. Everybody was of legal consent. Everything was valid. But the court came back and said, you brought your claim too late. Case dismissed. So it's a good tool. And you should, whenever you guys get claims, if you are, and like I said, hopefully none of you guys get claims in the course of your practice, but it's just the nature of the beast. If it's a claim that's a long time after you guys did that project, if you have to scratch your head and say, God, I don't even remember that one, talk to your lawyer about a statute of limitations. Say, we may be able to beat this on a statute of limitations defense. Okay. Any other questions? Yeah. A partially void contract. Yes, you can. That's great. That's a really good question. So I put a provision in every single one of my contracts because there's many, many, many clauses. When you guys get the B101, when we go through that, it's 27 pages, and the A102 or the A201 is like 44 pages long. There's all these paragraphs, and there's going to be and should be in every one of your contracts a paragraph that says, if any individual provision of this contract is deemed to be void or unenforceable, it does not delete or eliminate the remainder of the agreement. So there are sometimes cases where there are pieces that are pulled out and that create that portion of it's void and unenforceable, but the rest of the contract and the obligations stay in place. So that's a really good question, and that does happen. So you can make the argument, but then the other side's going to make the argument that there wasn't a meeting of minds on that. And so it depends, and that comes down into the facts and circumstances. Were the parties was the contract negotiated by lawyers? Would this be something that customary in practice that everybody would think that this piece is pulled out? It's a pretty boilerplate provision you're going to find in most written agreements, but that would become then a question for the court to decide, can we void the whole thing and just excise this one provision, or should I, as the court, toss the whole thing? And if you think about it, let's take this into something in the news that we hear, is like if there are challenges to statutes, like when the American Care Act or whatever, they try to void certain elements of it being unconstitutional, but not the whole thing. Or you come in and you parse things out. Sometimes it's a strategic position that you might want to take. If you could excise a portion and talk about that one, and you can prevail on that piece, and if you want to make a claim, that may help you settle the whole case. So there's strategy reasons of why you want to focus on certain provisions. The other side is going to say, yeah, okay, that one may be void or unenforceable, but the rest of it still applies. You still owe me money or whatever the dispute is. All right? Anything else? Okay. So let's talk about what the elements of a valid and enforceable contract. Since we talked about that's one of them. Okay. You need to have a proper offer. I want you to design for me a space, my new home. I will pay you $50,000 to design my new residence. I am making an offer to you. Proper offer. You understood what it meant. Proper acceptance. I agree to design your house for $50,000. The acceptance must be the acceptance of what the offer was. If you don't, and there's a couple slides coming up, if you don't accept the offer, if you change it, $50,000 is great, but it's really going to cost me $60,000, that offer doesn't exist because you haven't accepted it. So you have to have the mutual meeting of the mind. The offer and the acceptance have to be mirror images. There needs to be this mutual consideration. Mutual consideration, again, is this part of the bilateral agreement. Both parties have an obligation. Or one way you could look at it is both parties have to give something up. I have to give up my time in design. The other party has to give up their money to pay for that. So there's this mutual consideration or obligation. And then there's an absence of a valid defense. To make it valid, you can't have a defense. You can't say, oh, well, you're a minor, or you don't have capacity, or it's an illegal contract, or what have you. So that's the elements of a valid contract. And as I say, from time to time in the class, there will be questions on the exam that will have examples of contracts. And you may be asked, is this contract that I wrote out here, is this a valid contract? Is it void? Is it unenforceable? These are the elements that you want to think about as you're reading about what it is. Is that something valid or not? Okay. Termination of the offer and timing of acceptance. So now we have this, so let's talk about the offer element itself. That first part. Is it a valid offer? And can there be a termination of it? Okay. The recipients may reject the offer or make a counteroffer. In either instance, the offer then doesn't exist. I say to you, I will pay you $50,000 to design my house. You know it's going to be a $22 million home because I'm really rich. And you say, not a chance. My offer's gone. You come back to me and say, it's going to cost me $60,000 for whatever the deal is. My offer's gone. Rejection or a counteroffer terminates the offer. It doesn't ever exist from there on. Okay? An offer can also terminate after a reasonable period of time. You come to me, you find out that I'm interviewing architects and everything else. I've got 6 or 8 architects that I'm talking to. You're the architect I'm asking, and I say, instead of me offering you money, I say to you, so how much is it going to cost me to design this house? What are your fees? You say, well, gosh, I've looked at your design, your ideas, your program. I know what you're doing. I've done this a lot. I think it's going to be about $100,000 in design fees. Okay, I'll get back to you. I got some other interviews. And then it goes a month, 2 months. I do some more interviews. I'm not sure. I'm not in a real big hurry to move. And I call you back up. I call you up in 6 months and say, hey, I've decided to go forward with that house. Still good for that $100,000, so we're going to sign a contract. There's a question of whether that offer that you said I will do it for $100,000 is still valid. You're going to well, we're a lot busier now. So I would have to hire new staff. I can't do it for $100, I can do it for $120. No, you promised me you would do it for $100,000, so I'm going to force you, I'm going to sue you because we had an agreement. You said $100,000, you sat across from me at the table, and you said you could do the design services for me for $100,000. You may have an argument that says, no, my offer was terminated. The question here, and the reason why it's in quotes is reasonable, is what is a reasonable period of time? Is it a month? Is it 2? Is it a year? You'll find in the AIA contract there's actually a provision that talks about how long this contract is valid. Another argument that we made is at the first of the year, most people raise their rates. Every year my hourly rate goes up. So if someone gave you an offer in November and they came back and accepted it in February and the rates went up, the hourly rates of your team went up, would it be reasonable for me to call you up and say, give me your November prices? Probably not. So, the offer can terminate after a reasonable period of time. An offer will terminate as a matter of law. The law will enforce a termination upon death or insanity or the destruction of the subject matter. So, a family makes an offer to sell something, and the person who owns title to the property dies. Well, and they're the only person that's on the title. That offer, if the sale hasn't gone through, that offer is terminated and the law will not enforce it. Obviously, if the person that's trying to sell the property is crazy or has lack of mental capacity, the courts are going to say that offer cannot be, it's terminated because they may have gone insane later and they can't act on that. They have lack of capacity. So the offer will be terminated upon that. Or if the property has been, and we talk about this destruction of the property, of the subject matter, could be property, could be personal property. Say I was going to sell you a car, and you agreed to pay me $5,000 for my car, and then I got in an accident. I can't force you to give me the $5,000, even though it was in writing, because that offer to get the car was that the person who was going to pay the $5,000 thought was going to get the car that hadn't been damaged, but now it's been damaged. So the offer, you would argue, has been terminated as a matter of law. Does that make sense? A few more things. The party making the offer can revoke the offer, but it's effective on that communication, and that comes into an issue of lots of times of what is that communication. And the timing problems with that acceptance and revocation. So you call me up, we're talking, we have this interview, you say you're going to, we sit down across the table, you say you're going to design my space for me for my new house for $100,000. And then you call me up like a week or 2 weeks later, or you send me something in the mail and say, you know what, we went back, we crunched the numbers, we can't do it for the 100, it's going to be 120. You, by saying I'm changing the terms of the deal, you're the entity that gave the offer. By changing it, you're revoking that first one. I can't come back to you and say, no, you promised me $100,000. I told you it's only been 3 weeks. You can't say that that the offer is terminated because it's been too long a period of time. 3 weeks is reasonable in the business world. And you say, well, no, I communicated to you that actually that $100,000 is no longer valid. It's 120. That's my offer. You have revoked that first offer. But what happens with that? What happens in timing that can be a problem? So, there's the first one here. Offers and the revocations are effective when received by the second party. When I'm the other party on the receiving end, and I get the offer, when I learn about it, when I receive it, whether it's in writing or oral, that's when it's effective. Revocation the same way. So, we could go into the situation where we had a meeting. We sat across the table, you said you would do the design for $100,000. I'll let you know. A week later, you write me a letter. For some reason, you use snail mail. You don't text me, you don't email me, you throw it in the regular mail. And we live in Chicago and it takes 4 days to get there. So 11 days after we had this meeting, you send me the letter that says, we crunched the numbers and it's going to be $120,000. You have revoked your offer 7 days later. I don't receive it till 11 days. If I call you before I receive your rejection, your offer is still valid. I call you up. Hey, we're going to go forward with it. It's like day 9. I talked to my family. I talked to my bank. We're good for it. We really like you in the design. We're all set. I have my lawyers drafted up. We're sending you a contract, $100,000. Let's go. And you're like, no. I sent you a letter. Well, I didn't get the letter. Well, yeah, I sent you a letter 2 days ago. It's $120,000. Doesn't matter. Because offers and revocations are effective when received by the second party. I would have the valid right to enforce the $100,000 offer because it was not revoked. There's mailbox rule, which we're coming up here. Yeah, mailbox rule here. Okay? Acceptances are effective when made, even if they're not yet received. So when I receive, so let's say I accept something and I put it in the mail. And I send it to you, and so it's not the phone call. So we have the meeting. You say $100,000. I say I'll get back to you. And I put something in the mail, and it's going out. I put it in the mail on day 6. You send me a letter, you mail it on day 4, but I don't get it till day 8. And you don't get my receipt until day 11. So, I mailed my receipt to you before I got a rejection. You got it. You got my receipt of your offer. You got my acceptance of the $100,000 after I got your rejection. I call you up and say, hey, I just got your rejection letter. I just want you to know I already accepted your $100,000 offer. Not rejection, but I got your letter saying it's going to go to 120. I just got that. But I sent you a letter saying I'm accepted for 100. And you say to me, I haven't gotten your acceptance yet. Well, I mailed it 3 days ago, and I just got your 120 today. I mailed you the acceptance of the 100 3 days ago. That is a valid acceptance. So acceptance is upon when you accept it and whether it's received or not. An offer is only, or revocation is only upon receipt of the other side. So the mailbox rule is what happens if there can be multiple acceptance, and can you reject after you accept? What happens if you reject after you accept? So here's a different scenario on the mailbox rule. You say you're going to do the design for me for $100,000. I go out and look people, I interview, I'm like, okay, I don't like you. I found somebody that's going to do it for 80. So I start working with them. And I send you a letter, put it in the mail, and I say, thank you for your interview, I appreciate your time, we're not going to retain you. And I stick it in the mail. It takes a week for you to get it. In that week period of time, the guy that was going to do the design for me for 80, turns out he can't do it for 80. He's going to do it for 150. Can I call you up and say I'm accepting the 100? I've already put the rejection in the mail. You haven't gotten it yet. You don't know that I've rejected you. Question to you guys. If you haven't gotten my rejection, and you haven't changed your offer is always staying at 100,000. You have not received my written rejection. Can I call you up and accept that offer? Any ideas? What do you think? Can I accept it or no? Back there. And why do you think yes? Okay. And so the thing is here, revocation is rescinding the offer as opposed to rejection. But the question always comes in here, is acceptance the same as rejection on the mailbox rule? You reject after you accept, or you accept after you reject. Can you do that? And so there's laws in different states about how the mailbox rule is going to. In this scenario, if you have put a rejection in the letter in the mail, and you call up and accept later, that acceptance would be enforced, actually. Because then the parties have come to a mutual meeting of the minds, even though that rejection sits there. And they're going to be the accept. Now the flip side is, what if you accept in mail? What if you say to me, I'm going to provide for you the $100,000. I really liked the meeting. And so I write you a letter and said it was a great meeting. And I will accept your offer to perform the services for $100,000. And I send that in the mail. And then somebody who I thought was going to bid more bids less. And I decide to go with that person. You haven't received my acceptance. Can I call you up and reject there? And that instance is no. You can't. So if it's a rejection and you accept later, you can do that. But if you send that acceptance in the mail, if I sent that acceptance on the 3rd of January, and you don't get it till the 10th, and I call you on the 7th of January and say, I reject your offer. When you get my letter on the 10th that says, I accept your contract for $100,000, you can enforce that. Because acceptances are effective when made. Rejections are when received, which is like an offer. Does that make sense? On timing?
What is the initial discussion of the contract was done through mail? So, for example, if what we haven't spoken, and so I send you like a mail of an offer. how do you accept that? Because we haven't discussed on discussion or something, and you tell me that offer. Is there something by signature or something?
Great question. So the question is let's say we have the meeting and we don't come to a price. We just talk about the design and you say, I'm going to go back and I'll figure out customer numbers and I'll send you something in the mail. And then you send me this offer in the mail. We'll design your house for $100,000. And I receive that $100,000. How is that acceptance confirmed? How is that agreement? And the question is, do I have to sign something? Can it be on the phone? How do we communicate to each other? So it's a little bit less of whether the acceptance or the offer still exists. It's how does that become an agreement? How do we then bond that agreement? And the answer is, it could be in writing, it could be oral, it could be something by a text, it could be by email. There are various ways, but there needs to be a communication between the party who received your $100,000 in the mail to the party you that offered the $100,000 to establish that there was that mutual meeting of the minds. Hey, I got your letter. Looks great. Let's go forward. Hey, sounds like we have a deal. Or I signed this proposal, and there's going to be, in that packet that I get you at the last class, the second to last class of the year, there's going to be a letter, a cover letter. And it's going to say, attaches our agreement of terms and conditions of the services we're going to be providing you on behalf of as XYZ firm to provide you architectural services for project X. If you are in agreement with the terms and conditions to consider going forward at least with the base numbers, and the letter will have design of a house, $100,000, just the basic business terms, please sign this letter here in the spot below, and you'll ask that to happen. So that's the recommended course. But a lot of times I have clients that say, well, I just called them up and said, go for it. Or I called them up or sent them a text. So the only way when that offer is made, if it wasn't in person, to complete the deal, is there needs to be communication between the parties that we agree, that mutual agreement. Did that answer your question? Okay.
What happens to the timing of email? Like someone can send an email and then the party that's receiving it would open it for a day.
Well, that's an even better question, because like the mailbox rule is much less relevant nowadays because of email, but the concept still applies. When you press go and you send out your offer on your email, when you press send, that's the same as I've made an offer. If they haven't opened that email for 3 days and it goes off their screen and it scrolls down, I'm sure I know I'm guilty of this all the time. You may get, over a course of a period of time, 3 or 4 emails from the same person. And sometimes we tend to go top down and it'll be backwards chronologically. There'll be times when I'll read an email and I'll respond to the client and then I'll keep going down and be like, oh, he already answered that question because it was in an earlier email. So if that scenario happened, let's say you made me an offer and the offer email kind of scrolled off the bottom of my screen and later on I didn't open it. If you can show that the person who received the offer, the receipt and as far as is that offer good and valid, it's when they're received. Those are things that you have to look in for the timing. So the mailbox rule still applies. It's just it's going to be normally a much more shorter window, and the proofs are a lot of times the proofs are they're more difficult and less difficult. In many instances, it's easier because every email has a timestamp on it, whereas the postmark, the mail may have just a postmark, and still may take the mailman 3 days to get it to you. But then you have to look in the computer, and electronic discovery is a big deal in litigation. You can show when emails were opened. I mean, that's part of the metadata that people find. So same purpose, same rules apply. Okay, any other questions on this? Okay. Consideration. I talked about consideration. That's that everybody has an obligation to each other. So what are the legal concepts of consideration? Okay. It's the giving or agreeing to give something of value. Now, value is this kind of interesting little term here because when you enter into a settlement agreement between parties, sometimes you may say, for good and valuable consideration agreed, or for the exchange of $1. There's a movie that probably none of you guys have seen, but maybe you have. It's called Trading Places. Eddie Murphy. It came out many, many years ago. And Eddie Murphy's this kind of bum on the street, and there's these two very rich guys, and they take him on the street. They take him off the street, and they make him rich and famous, and he becomes this in the business world and everything else. And then there's a question later down the road is, can they dupe him into become and show him that really he doesn't belong? And toward the end of the movie, the two very crusty old gentlemen, the rich guys, shake the hand and they exchange $1 because they had this bet. That's the valuable consideration of what they couldn't do in the deal. So what is value is subjective, but you need to have, both parties need to give or offer to give something of value to either side. In your world, going out there, it's, I will give you my time and you will get a design from me, but the value that you're giving is the time. And my response to you, the value that I'm giving you is, I will pay you for your time. That's the mutual consideration. Consideration could be doing something that is to your detriment. Well, your time is your detriment. It takes you away from other projects. Or you could do something else that maybe could cause you potentially harm. That's consideration. I'm doing something that puts me at risk. So it doesn't necessarily need to be monetary. I'm putting myself at risk. That's a value to me. I'm taking myself away from something else. Examples that we've talked about: money, performing a service. That's what we talked about. Giving up of ownership of something. I will give you this. It's not necessarily money, but I'll give you a car. I'll give you in-kind services. Or I agree to forego anything that possibly has value. I promise I won't. If you do this service for me, I won't take this away from you, or I won't enforce, evict you from a property or what have you. There's things that I forego that I could do, but in exchange for you performing services, I agree not to do that. Now, it can't be an illegal activity because that would make the contract void, but you are giving up something. You are foregoing the enforcement of something in exchange for that service or goods. Does that make sense? That's consideration. A couple other things. Illusory promises do not constitute consideration. So, illusory is like, well, I promise I'll do this for you, but you've already had to do it. It's not really consideration. I'm trying to think of a good example of an illusory promise. I keep thinking and get back to you. Let me go back. Let me finish these other two, and then I'm going to try. I'll come up with something. Consideration for a third party. So the third party actually can give the consideration. So I had a case where the contract was entered into between a woman and my client, which was a design builder, to build a strip mall. The party, though, that was set up to pay was the father of the woman. She was not a minor, but he had all the money and he had developed. He basically wanted to develop a strip mall and as a generational wealth, give her a property. So the agreement structured that the payment needed to go through the father. The woman didn't pay any of the checks, but that is considered a third-party consideration. So the contract between the woman and my client was valid, even though the third party was the entity giving up consideration. So you can have that there. Substitution for consideration is detrimental reliance, meaning, well, I relied on you to act, and so I performed this service. I thought you were going to. I relied on your actions. I relied on this happening, so as a result, I provided the services. That's the consideration, is what I gave up as my reliance on you, not necessarily my time or other. Let me think back of an illusory promise, something that's good for you as a sample. So, you have obligations to drive safe. You have to perform services to drive in the street, or maybe a cab driver. They have to follow the rules of the law. Someone can't charge you additional money for following those rules, for driving in accordance with the rule of the law. They can charge you for the services of driving, but they can't say, well, I got you here and we didn't get a ticket, so you pay me more money. Well, That was not a promise. I mean, I promise to get you on time, and I promise you're not going to get a ticket, and we're not going to have any problems with the law. Well, that's an illusory promise. You can't get extra for that because you always had to abide by the law. So if one individual, no matter what, still had to perform those duties or services, they are not giving anything up. If they had an obligation to do that already, they have not given up consideration. They haven't given anything of value because they always had to do that. As the designer, you always have to design in accordance with codes and statutes. You're not going to get paid extra for that because that's what your obligation is under your professional obligation. Question?
You just explained here what consideration has to do with the contract. So is that things that you're changing have to be
of value. So you have an agreement of mutual parties, the bilateral. I do something, you do something. You design, and you're giving up time. I pay you, I'm giving up. What you give up is of value to you. Something of value to you, you give to the other side. Money to you, time to me. That what you have given up is the consideration between the two. It's not the agreement, you're going to provide me a design. Giving me the design is the end product of the contract. That's the result of you doing all the duties under the contract. The consideration is you're going to give time to create those designs. My consideration is you're going to give me that agreement I'm going to build, or those designs I'm going to build it. That's again the end product. My consideration is when you give that to me, I'm going to give you money, something of value I'm going to give to you. So it's not necessarily the exchange of services, but it's of what you have given up is the consideration.
So if what you're giving up is like percentage of value that's actually not, then it's not. Like let's say I charge like $10 an hour for my services.
Yes.
But really my services are only a value of $1 an hour. Is that like not
It's a good question. So the question is okay, if you have a $10, if I charge you $10 an hour, but normally I charge everybody else $1 an hour, is that $9 delta? Is that giving up consideration? Well, first of all, no matter what, the $1 an hour of the services that you provide that you should be paid for is consideration. The value, that has value. Because that goes back to this earlier slide. What is value? That's number one. But if you guys come to an agreement and I don't care if you charge $1 or $200, if I feel $10 has a fair value, you've given me a value of $10 an hour. So that's also a subjective issue. It's the different question is if you're a volunteer to do something, if you volunteer to provide services at a shelter or what have you, and someone comes in as the recipient of that, have you given something up? In that case, maybe you've given up your time. But if the law requires you to do something, again, you have to design in accordance with the code. You have to drive your car in accordance with the law. You can't charge extra. You are not giving up consideration. You can't say, I drove you here, and the meter says $10, but we didn't run any red lights and we didn't get a ticket, so you owe me $12. Well, what does that have to do with it? The meter says $10. That's what you should be charging me. That's the value. Yeah, but we didn't get in trouble. I didn't break any laws. You're like, I don't care. You're not allowed to break the laws. That additional has no value. That's not consideration. That's illusory. Does that make sense? Okay. Defenses to otherwise valid contracts. So now we have what we think is a valid contract. The parties are the same of a legal consent. Everything's written down. We think we're all there. We're all good, or are we? And this is where the lawyers come in. Mutual mistake of fact. Design me this house. It's going to go in this area that used to be a commercial industrial zone. But we have talked to the alderman and we're all good. The alderman told me, and you did some research investigation, it's going to be rezoned residential. Okay? You both thought the facts were in your corner. But it's a mutual mistake. So when you design it and the guy says, well, I'm not going to pay you for that because we both had a mistake of what it is. That's a defense for the services. Or if both parties, whatever the agreement was, if factually they both didn't understand what it was, there was a mutual mistake, no matter what it is, you can say that contract is not valid. We never really came to a meeting of the minds, even though we thought, because on paper or in our discussions, we said mirror issues. We were both mirrored on what it was. But it turns out that what we both understood, the zoning was residential, never existed. That contract is not valid because it was a mutual mistake of fact. So that's always kind of the difficult one. And what ends up happening a lot of times is people argue a mutual mistake of fact, and it turns out that it's really not mutual mistake. It's, well, I thought it was this, and you thought it was that. Is that a mutual mistake? No, because the mistake that's mutual isn't mirror images. But so that's not a valid. That's not a defense as a valid contract. The mutual mistake is we both thought it was going to be the same thing, and some other fact out there that we both thought was wrong, was different. Okay? Unilateral mistake occasionally comes up, but it's typically not a defense. You told me you were going to do A, B, and C. I thought it was A, B, and D. I didn't understand you. Your defense is A, B, C. It says it right there in the contract. I never was mistaken. You made a mistake. That's not my problem. That's your problem. That is not typically a defense. Now, there are some instances where there can be a unilateral mistake. There can be situations where the understanding by one party is sufficient, and it is a defense. You knew the zoning wasn't residential. You were just going on the approval and the recommendation of your alderman that they were going to change that. So you always knew that there was a problem with the zoning. You told me that this was already zoned residential. You told me that that was already changed. Or that was my understanding. I'm the only one that was kind of left in the dark. You could make the argument as the design professional the contract is invalid because my unilateral mistake. But it's much more rare, and it's much more difficult to prove. One could make the argument on the other side is, hey, you're a design professional, you understand codes and zoning, you should do your own research, you should be able to look at that. So it gets down to it. So unilateral mistake occasionally happens, but it's a rare instance, and it's difficult to enforce as a defense. We talked about this a couple before, fraud, illegality, lack of capacity. If someone lies to you going into the contract, they know they're lying to you about the terms and conditions, that's fraud. Contract is no longer valid. If it's illegal, minors or what have you, or I'll pay you $100,000 to deliver drugs for me, that's not a valid contract, that's a defense. And lack of capacity in contract. Continued. Duress or coercion. The strong arm. If you do this for me or I'm going to hurt you or I'm going to do something, I'm going to take away your car or whatever. That's what parents do to kids all the time. They enter into these illegal contracts with their kids by saying, I promise you the allowance. If you do this, that's not legal because they're void, because they're minors, and because the parents assert duress. I mean, it's not really contracts, but that's one way that you can have a contract that is considered invalid. You don't have to perform. What's interesting in the concept of duress is what contemplates or what ultimately is duress. Is it physical? Is it psychological? Is it monetary? Is it business? Those are types of things that you come into play. Economically, was it going to hurt you that you had to sign this document? Are you forced to sign this agreement because economically you're going to be hurt? Is that duress? Are you forced into it? A lot of times what the courts are going to do is they're going to say, you know what, there's a contract here. You guys, maybe you were under duress, but maybe not. You came to an agreement, and so it's difficult. The party that wants to assert duress as a defense has to make a pretty clear showing of the facts that are not in the contract, the extraneous facts, to show why they're under duress. You'll have the situation where it's the mom and pop shop and the big corporation, and they enter into this deal. Mom and pop shop are going to sell a product to the big corporation. And the big corporation asserts its willpower on the small mom and pop and just hammers them and hammers them and hammers them to get down the profit, the cost to buy this product at the bare bones minimum price. And it's because the company feels, this mom and pop shop, if I don't sell my product to a big corporation, I'm going to go under. Is that duress? You got this big controlling interest, and you have this small little company that is doing everything they can to just eke out a living to barely stay alive. Is that duress or coercion? Most of the time the courts will say no. Now, if you can show a nefarious or concerted effort by the big corporation to try to undercut them, to try to get the dollars down, if they do something extraneous to try to force that, then they'll probably go ahead and enforce duress or coercion. But most of the time the courts are going to say, people are out there, they make their choices with business, they do what they have to do, the market is what the market is. And if some entity may have a little bit more leverage and bargaining power and asserts that on the market, that's not to say that we're going to eliminate that contract is a valid or invalid contract. So, duress or coercion happens more per personality and individuals, less on the business side. So, statute of limitations, I talked about that, what the concepts are in Illinois. Statute of limitations is 10 years from a written contract for normal contracts, just generally. So if I enter into a contract with you to provide services, not design services, but to shovel your lawn or shovel your walk or whatever it is, the written contracts can be enforced for up to 10 years. Oral contracts or implied contracts, 5 years after the agreement was entered into. So any lawsuit or claim that happens after either 10 years or 5 years, there's a defense to that contract, they can't prevail on it. That's generally. But for construction, and this is the only one you guys really need to care about, is it a little different. So they carved out this role in construction because people should know about problems in their houses more than 10 years. I mean, if it's going to be leaking, well, they shouldn't have to wait 10 years after the leak started to bring a lawsuit against you. So there's two little things in the construction world in Illinois. 4 years of statute of limitations from the discovery of the problem. You design a school for me. We open the school January or September of 2018. It starts leaking in February of 2019. I have now discovered, even though it's a teeny tiny little leak, and I don't know that you guys have committed a design error, I don't know it's your fault. From February of 19, when I discover that leak, I have 4 years to bring a claim against you. So it's 4 years from discovery of the problem, or there's this thing called 10 years from the date or act or omission. That's called a statute of repose, which is a little different thing. You designed this space for me and you finished the drawings in July of 2018. Okay? If my building starts leaking in June of 2028, 9 years and 11 months later, I'm within this statute of repose period. Because you are basically guaranteeing, or not guaranteeing, but tell me that your design is valid for at least 10 years. But that's when you did the drawings, not when we built it. So now, you gave me the designs and they finished in June of 2018? July of 2018? Let's say it's July 1st. If the building has a design defect all the way through June 30th of 2028, I have a valid claim against you under the statute of repose. It's the discovery. I have 10 years to discover you did something wrong. If I discovered it on July 2nd of 2028, no claim. But up to June 30th of 2028, that 10-year period, I can discover and say that there's a problem. And then, interestingly enough, I have 4 more years to bring the claim. Because no matter what, I have 4 years from discovering the claim. So I can find out and say it's leaking due to your defect on June 30th of 2028, and I don't have to sue you until June 29th of 2032. So you have 14 years in Illinois to potentially bring a claim. Does that make sense? Yes, question.
Like the discovery part, that time frame.
So, how do you figure out if it happened, or what?
So, you find out there's a leak, and then you have those 4 years, so how is that on record, that there's 4 years from that?
It's a great question. Yes. So how do you establish when that clock, this 4-year clock, started ticking? How do you figure that out? You're going to tell me, you, the person who discovered the leak, are going to try to tell me it's as late as possible, so you have as much time as possible. But that's what the depositions and the interrogatories are. You go in and you talk to, if it's a leak in the gym, you take the depositions to the gym teacher. Did you ever see leaks here? And he's under oath, or she's under oath. Yes, I did. When did you see him? Well, I don't know, I saw him like 3 weeks after we moved in. It's been leaking since then. And if you didn't sue me for 6 years after they moved in, then I would bring a motion to dismiss outside of the statute of limitations. Now, what's interesting, and here's where people get confused on this tenure date. So let me see if I can explain this to you so where the confusion is. You finish your drawings in July of 2018. It's a 10-year period from that for me to discover. But based on, to your question here, let's say I discover in 2020, only 2 years after I've moved in. So the 10-year clock has started ticking. We're 2 years outside of the 10-year clock. At this point in time, the 4-year clock starts ticking. So I have to claim to you 4 years. So from when we moved in to where I discovered, 4 to bring the claim. We're only 6 years into this 10-year period. If I bring it outside of that 4-year period, even though there's still 4 more years left in that 10-year block, it's not a valid claim. This 10-year window goes away as soon as you discover it, and the 4 years starts clicking. So you got 10 years, click, 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 discovery, only 4. Doesn't matter after that. Does that make sense? Okay. Statute of limitations, like I said, comes up all the time in what we do. So that's kind of important. Another defense, unconscionability. Terms are so extremely unjust or overwhelmingly one-sided in favor of the party with the superior bargaining power. This goes back to potentially duress and coercion, but again, you're going to find a situation where the courts are going to be less likely to enforce that. In the business context, they can, but it's an unconscionable contract. Come on, guys, you had them over a barrel and you charged them hundreds of thousands of dollars for something. Is it an unconscionable contract? It's contrary to what good conscience is. It doesn't feel right. It doesn't pass the smell test. And this type of defense is something where if you're in a dispute, you're probably going to want to have a jury. And you're going to say, does this really feel like they should have done this? You're going to be basing it somewhat on duress or coercion. My client shouldn't have to pay the other side these exorbitant rates because they got screwed and they had to do this. They were they got put in the situation and the other side had all the bargaining power and extracted it from it. And so you would want the jury, you want to go an impassioned plea to the jury to see if you can prevail on a defense to that consideration by unconscionability. Yeah. How do you prove a contract? An oral contract. That is a great question. How do you prove an oral contract? It's difficult. You have to do, what you do is when you're talking to your client and they say, I entered into this oral agreement, you're like, okay. Or sometimes you even have like a written contract that's never signed. The parties exchange the writing back and forth, but it's never signed, so that written contract has never been validated. What you have to do is say, did you have any letters? Did you have any communications? I know that's not the contract, but these outside facts help to support your client's side of what they believe the deal was. So the deal, the true contract, were the discussions between the two parties and their shaking of the hands or the go forward or yeah, I agree with that or whatever it is. That's the true contract. And you take all of the facts around it, depositions, interviews, other comments and communications, parties' actions. Somebody who actually showed up, we all agreed that they were going to start on January 1st, and people showed up on January 1st and they started working. This crew wouldn't have shown up to your house to start working on that if there wasn't an agreement. So you show the facts around to help support. But at the end of the day, what's going to happen is, if you have to take it all the way to trial, is one party's going to go on the stand that was part of the deal, and they're going to say, this is what I thought the terms of my oral deal was. And the other party's going to get on the stand, they're going to say, this is what I think the oral deal was. And the judge or jury is going to hear both of them. They're going to see who's lying or not lying, or who they believe, or whether they, it's not necessarily that they lied, but who has the better story, who had the better understanding. They're going to take all the other facts and circumstances, the other witnesses, and they're going to put them together, and the jury or the judge will ultimately basically tell you what those terms of the deal are. A lot of times you're going to have a situation with an oral contract, if you take it all the way to its final end in trial, and the deal that is struck at the end of the day is not what either party thought the deal was. It's a little bit, a little of that, or a lot of this, a little of that. So oral contracts are difficult because we hear things and think things differently on the other side. It just always happens. Question?
And to answer that question, how about something was recorded?
Like a recording?
Yeah.
Yeah, so that would be facts, and it's interesting. The question is so is the recording while the discussion's going on, is that the contract? That's a really interesting question. And I said, I don't know if that would be arguably the contract. I guess you would use it, what I would say is I would use it as evidence of a contract. I would say, I would put my witness on the stand and say, what did you think the deal was? Well, it was this, this, and this. Why? Because this is what we talked about. The other witness goes up and they say it's, A, B, and C, and it's A, C, and D. It's just a little bit different. And that's what they both think the deal was. And then I would say to the judge or jury, just like I talked to this other witness, or these people showed up on the site to start working, or whatever it is, I would say, let's listen to this recording. And you can hear them talking about it. And you can hear, and I would point out to the court or the jury, here, this is where they said A, B, and C. And nowhere do you hear in this discussion at all anything about D, and certainly you can hear B, whatever those circumstances are. And let's listen to the end where they say at the end, yeah, let's go forward with it. So I would use it as evidence supporting my client's side of it, but I don't believe that recording itself is actually the agreement, because what I probably would happen, and I don't know this for sure, but my suspicion is, for that to be actually the agreement, it would have to be transcribed, and both parties would have to sign to say this is what the agreement was, and then it becomes a written contract. So it would be evidence, just like anything else. Any other questions? Yeah.
So if you have an offer and then you have a lot of reply from the student end, is that like an automatic acceptance?
If they have a lack of reply?
For instance, if you just request an offer.
So that's an interesting, it's interesting because I was just reading something in the news yesterday about a criminal prosecution and how this big Bob Moss handled things, and whether that was an agreement and they used it enough to convict him. So if I'm in there and I have a discussion and I say, I'm going to go ahead and I'll do those designs for you for $100,000, and we get up and we shake hands and you never say go ahead, I think you have an argument to say I never agreed. I was just shaking hands because it was the end of the deal. And I start working and I send you an invoice and you write me back and say, what is this? I never agreed to that. I think you need to have, my argument would be is you need to have an overt action on the other side showing that there's an acceptance. Now, does it have to be, while we're shaking hands, I agree to the $100,000? No. Could it be, hey, that sounds good, let's go forward. Or sounds like a good deal. Or something like that. But the further you get away from this mirror image, the offer and the acceptance of how you accept it, the more difficult it is to prove that contract. The example I was just mentioning is they were talking about there was a conspiracy argument as to how they got one of these mob bosses, and it was difficult. They did end up prosecuting him, but he never I don't know if it was unique to him or whatever, but he would never would instruct his lieutenants to actually do anything specifically. He would ask them questions, and the way he asked the questions would actually support knowledge that that's what he was telling you to do. So for this instance, this mob boss, they had information that one of their lieutenants was actually an informant for the FBI. And so the trial later on was the murder because they killed this guy. This second lieutenant, they ended up being murdered, and so they indicted the underling and the mob boss for murdering of FBI informant. And when the testimony came in, one of the second lieutenants flipped, and he said, "Well, what happened in the meeting?" Well, we went into the meeting, and they reported the first lieutenant, the guy who flipped on the mob boss, reported, "Well, we found out that he did this, this, and this. He was reporting to the FBI. He was taking this information." So it was report on the facts of what this murdered individual did against the mob boss and his organization. And instead of the mob boss saying, "Well, let's hit him, let's take him down," the mob boss, according to the guy who flipped later on in the trial, said, "What did he do next?" And the mob boss said, "Are you sure he did those things?" And the lieutenant said, "Yes, he is. Yes, I am." And that was all it was. He didn't say, "Okay, go ahead and kill him." But the way he asked the question was, "Are you sure he flipped on us?" Or "Are you sure he's an informant?" Or "Are you sure he did these?" And by saying that, he was instructing. Now, that's not necessarily a contract because the whole thing was illegal and everything else, but you can have scenarios in an oral contract where the communication of acceptance isn't necessarily clear. "I accept your $100,000 offer." It could be, "Go ahead, sounds good." And then you have to prove that that's what the parties meant. Okay? All right, last slide. Assignment of rights and delegation of duties. So contract, again, remember, it's between two or more parties. They have mutual consideration. They're going to be providing services back and forth, duties and obligations. What happens if a third entity comes in? Can one party assign all the things that they agreed to do in the contract to a third? The answer is yes. Assignment is giving a contract right or duty to another party, and the first one is disconnected from the transaction. This happens all the time in business. A lot of times when businesses are sold. So I'm that mom and pop shop, and I've agreed that I'm going to be supplying a widget. A widget is a term used in law. It's a product or a piece, whatever that mom and pop shop makes. I'm going to be selling widgets to the big corporation, and I'm going to turn out 100,000 widgets a year. That's my contract. You're going to pay me for that $100,000 a year. Mom and pop shop ends up getting bought by a little bit larger company. Not the big giant company, but a smaller company. Mom and pop shop, they want to take the $1 million they got, they're going to retire, they're going to move to Florida and live happily ever after. But they have a contract with the big corporation. Mom and pop shop assigns the contracts to the new company that bought them. The new company must still provide 100,000 widgets a year to the big company. Big company must pay the same dollars to the new company. If the new company only produces 90,000 widgets a year, because the assignment has been given to the new company and the original company has been disconnected, a full assignment, mom and pop can still live in Florida and have a great time and not have to worry about the 10,000 unit shortfall. It's new company that has the obligations, like they were the first persons entered into the agreement. So it's an assignment of all rights. Delegation is different. Delegation is the same assignment, except the giver stays involved in the transaction. Mom and pop, when they sell this company, still want to have a little bit of the party, they part of it. Maybe they want to get some extra profits. Maybe it's a long-term buyout. Mom and pop take $400,000 of the million, they're going to get paid over the next 6 years to get to the $1 million. They go to Florida, but they have delegated the duties of the contract to new company. If new company only provides 90,000 widgets to the big corporation, and big corporation sues because mom and pop are still involved and they haven't assigned but only delegated the duties, mom and pop can be liable. Question? Kind of. That's a really good question. So I'm an owner. You've already provided me wonderful designs for my house, and I need to come to you because you're a contractor. And I say, you're going to build this house, here are the drawings. Well, you then don't do all the electrical and plumbing and everything else. You hire these subcontracts. But my contract with you is to do everything. Now, you're not going to take your actual contract and delegate elements of that contract specifically to the subcontractor. What you're going to do is you're going to enter into another contract. So it'll be owner, contractor, subcontractor. And there's going to be terms and conditions between contractor and subcontractor below of how those contracts work. You have in some ways delegated the obligation to perform the electrical work to the electrical subcontractor. So there is a delegation, and you have stayed in place. But I can never make a claim against the subcontractor because I'm only going to come against you. You have definitely delegated duties of your agreement, but you still are on the hook for the agreement. In my example of a delegation, it's mom and pop are now out of the business, and it's new company doing everything. But there is still only a delegation of duties because mom and pop want to stay involved in the financial transaction. So that's a little different, but similar concepts of who somebody else than the original party is obligated to perform those services or provide those goods. What can be assigned or delegated? Personal duties typically cannot be assigned or delegated. You're not going to go in and have a brand new movie and you're going to hire, some new hot star and then they say, well, we don't want to do the movie. We're going to assign the rights of this contract to another star. You can't do that. Or you're going to have somebody that's come in and they're going to do specific work on your house. Well, you hired that person. Let's say, you need your floors redone and you got a specialist to do the floors. That flooring guy can't say, oh, I'm sorry, I'm busy. I have another company that's going to come do it. The services typically cannot be delegated. Duties, though, general generic stuff, if it's not specialized, general generic stuff can be assigned and delegated. So an electrician, you can assign the obligations. Well, normally what happens is a general contractor, you do investigation on the general contractor, and they're reputable, and you know that they work with high-level subcontractors. That's part of your due diligence. Say, well, he works or she works with good people, so when they delegate those obligations, you know that their trades are going to be just as good. When you get into large-scale contracts, of which I work on all the time, contracts that are in the tens and hundreds of millions of dollars, what we say to the general contractors before we enter into the agreement, before we actually retain them at all, it says, give us a list of your trades. I want to approve all your trades first. And then I also include language in the contract that says, if your trade doesn't perform to my standards, I can force you to terminate them and bring somebody in that I think is better or is of equal. So you can protect the interests. So even though it may be a generic duty, electrical or plumbing or carpentry, there's still some things in the construction world that you try to keep a level of quality that you can do. So, question?
Are you assigning a contract or delegating to the receiver of the contract or president?
Yes. Yeah, so when you're assigning something so I have an agreement with you, and for whatever reason, my company's been bought, or I'm retiring, or what have you, I'm going to assign the contract to her. I write to them, and I write you, because a lot of times the assignment has to be approved in writing by both sides, and everything that I'm supposed to do for you in the contract, I have translated and put it all over that, and she has those duties. And if it's delegation, I'm still involved, and so you can still sue me if she doesn't perform. If it's a full assignment and it's been agreed to, you can't sue me. You just go back against her because she's failed to perform. Okay? Yes? Is the what? Correct, yeah. It's the giver stays involved. And so it says, they're involved and they are not removed from it. So they have liability. They can be held accountable because their delegation wasn't done properly, or their oversight obligations, or a whole host of it. And that's where the subcontract agreement question is actually a good one. It's not completely true because you can, in a delegation of duties, depending on how it's written up, the recipient can sometimes bring a claim against both the original person in the contract and the third party that's been brought in. So, recipient, if there's an assignment, only has a claim against the new party. If there's a delegation, the recipient has a claim against the original party and potentially, likely, can have a claim against the new party. So they would have two claims going on there. With the general contractor and subcontractor, because of the, and I'll have a slide next week so you can kind of see graphically how this looks. Other classrooms I had, I don't want to write on this, but other classrooms I've had, I can write stuff, or maybe I'll bring up the whiteboard next week. But the chain is the contractual privity of how the lines go. Means the owner can't leapfrog around and sue the subcontractor directly, has to sue the contractor. So the contractor has delegated duties, but in that instance, there won't be two lawsuits, there will be one. Question?
So, like the subcontractor, contractor, like the delegation, is it because the contractor creates a new contract with the subcontractor, but the owner can sue them because it's a separate thing, but in the delegation it's the same contract that two different parties are?
Well, depending on where the delegation goes, I mean, you are technically correct. Anytime a subcontractor has been involved, the contractor, whatever duties that sit in the four corners of that contract, the contractor has delegated those duties. And so that contractor is always involved. But depending on how the delegation is listed and identified, the owner may have a claim against the third party because of their expectations of what the third party is performing. Traditionally, though, in the way the contractual language is written, is in construction and other things, that chain, owner, contractor, subcontractor down below, there is no connection other than this entity is performing. But technically, the subcontractor is performing for the contractor, of which the contractor is bringing everything upstream. The scenario that I'm talking about, the same delegation where there's three, is the new party is truly performing for the owner those delegation of certain rights and obligations, so they transfer, but both parties now carry the same rights and obligations. Okay? And I believe that's it. Last question, or not last, but another question?
Did you enter into a contract under the influence of like alcohol or something? Is that still a valid contract, or did you make that like unenforceable by a capacity?
That's very, yeah, I would make an argument of capacity. You know, alcohol or drugs or what have you, if you can show that you are specifically not at capacity enough to actually have clear thinking, and that goes to the ultimate question of a meeting of the minds. So capacity is just a sub-element of there's a meeting of the minds. In fact, minors, the reason why the law of the minors is in there is because the law has decided, they have made, whether it's proper or not, they have established that at 18 years old, everybody, once you turn 18, you can think on your own. And before you're 18, you can't make decisions on your own. The laws have to make some type of bright line, so we've decided that 18 is. But ultimately, the concept is a minor doesn't have the capacity to enter into agreement to think about it. Someone under the drugs or alcohol doesn't have the capacity. They're all in this, that there was never a meeting of the minds. They don't have the mental facilities to come to a true meeting of the minds, whether it's artificially invoked because it's the age of 18 or otherwise. But that's the point there. So, all right. We'll see you guys next week. Thank you.